So next up in our program, it gives me great pleasure to introduce Stipe Vuleta, Managing Director of Chamberlain's Law Firm, Sydney. And I hope did I get your last name right? Vuleta? Probably, yeah. Not quite, but yeah. Anyway, all right. Now, here's your intro, right? You can just come up slowly. I got this from one of your bios, and I think it's about right. He's almost always the youngest person in the room, but when Stipe speaks, even the oldest hands listen. So, yet to be seen. No, just joking. Stipe has worked on multiple cannabis-related matters, including creating a framework on employee rights and protection for medicinal cannabis patients in Australia. He believes that cannabinoid medicine should be treated like all other medicines, and is a regular presenter on the topic of medicinal cannabis and the law. He's here today to talk to us about his presentation, which is titled Medicinal Cannabis, Legal and Regulatory Implications for Nurses. Please welcome Stipe.
Thanks, everyone. Look, I'm not used to presenting on camera, so I appreciate it, and I'm honoured to be here today. I try to take these things pretty casually, so today I'm going to be really dealing with two things. And as far as I'm concerned, as people involved in the healthcare sector, particularly nurses and midwives, we tend to think about two things, and that is how regulation and the framework that we're required to deal with every day affects the way we're able to deal with patients. And this can prevent some really perverse outcomes, as I'm sure a lot of you are aware of. And then also how the current regulatory framework affects us as people involved in the healthcare sector and our engagement as potential or actual patients of medicinal cannabis. And so these are two really distinct things, but I often think that in the context of considering issues like regulation, we don't often look inward enough as well, because ultimately the health of the people that look after the people that need to be cared for is just as important as the health of our patients. So I just want everyone to consider that in the context of my presentation. And if I click something wrong, please laugh at me and heckle me. It'll make the whole process much more enjoyable. So basically a bit about me. I really, really like pizza. I've suffered from anxiety from the age of 14, and after a period of a pretty unhealthy extended use of antidepressants, I found medicinal cannabis myself, and I became really passionate about the topic. So that's how I come to you today. Someone in the office wrote that. I think it's pretty true. We're an old school law firm. We're trying to have fun with it. And I think with something so important like this, if you can't have fun and if you can't laugh at the dysfunction we're all facing every day, then you'd cry. And I try to make an effort not to do that so much these days. So we all know medicinal cannabis is sort of legal, right? It's not really legal. It's sort of legal. The process by which people get access to medicinal cannabis is incredibly complicated. I was just chatting to a gentleman outside who said that if you drew a flow chart of the regulations and you dropped them off a 2-story balcony, they'd probably hit the floor and keep going. So I'm going to try to make it a non-legalistic presentation and really talk about what I think are exceptions and interesting issues that come up. And maybe if someone has any questions along the way or any thought bubbles, throw them at me. I want to keep it discussionary, though I know it's a big room. Regulatory regimes. So I'm going to put it out there. Everyone has a different view of the TGA. I've spent a lot of time in my career dealing with a lot of different regulators. And the one comment that I'm happy to say, obviously Chatham House rules, is that I have a strong view that the TGA's own interpretation of a lot of these regulations is very likely narrower than what the legislation and appropriate regulations say. And so that creates in and of itself a lot of uncertainty for nurses and for other people involved in the medical sector when they're trying to figure out what their rights are and how they should act in the workplace and how they should look after their patients. And that's a really big problem because on the one hand, we think about, well, what do I understand my obligations to be when I am undertaking my professional obligations versus what someone else who has the power to punish me and punish my employer believe to be the regulations and how they're interpreted. And as lawyers, ultimately we represent clients and our clients are not always the TGA. And so I guess I just say that with a bit of implication. Now, before we get onto employment law and cannabis, I would like to really just talk about a couple of issues, in my opinion, that come up under the current regulations. And the first one is access in a ward setting, access in an aged care setting, access in a formalistic setting for the medicinal cannabis patient. Now, we all know the process by which medicinal cannabis is prescribed in Australia. I'm not going to go through it, but the fundamental issue that arises is the nature by which particular products have to be prescribed. And that ultimately creates, in my view, at least from a legislative legal perspective, I've never worked in a ward, I've never worked in a hospital, a major problem for healthcare practitioners, for nurses, when they're undertaking their day-to-day work. So there's ultimately three different hypothetical scenarios, in my view, when you're considering the way the current regulations operate. And the first one is a patient attends a formal healthcare setting and they provide their own script and product. And so the reason I put this one first is Lucy actually raised it with me earlier today. This ultimately comes down to education and employment law and policies within the healthcare workplace. Often people are engaging with patients who are showing up with a completely valid script and a completely compliant product that they've purchased, and they're being told that they're unable to take their treatment or have it be administered to them in a formal setting because of a lack of education and understanding. And so I wanted to raise that as a very important point to begin with, because it's something that a couple of people here have raised as an important, almost non-legal, practical problem that arises. But if we look at then the way the rest of the regulations work, we end up with two other strange outcomes. The second outcome is, for example, myself, a medicinal cannabis patient, I show up to hospital for an unrelated injury and I end up staying there under the care of particular practitioners who may not have exposure to this particular part of the sector and medicinal cannabis regulations that we all have. And 2 or 3 days in, I'm unable to get access to my product. And that's ultimately because of the restrictive way in which medical practitioners, nurse practitioners are able to get access to scripting for their patients. And that's just a fundamental issue. And we've all heard stories of, people who might be suffering from severe mental illness or even, physiological injuries where their usual medication would be such a more humane way to treat them, but ultimately they're being forced to go on to more quote unquote traditional medications purely because of access. And the hospital pharmacy may even have some medicinal cannabis products available on the day, but they're not compliant with the scripts. And the process for getting something changed is so laborious and time consuming that someone might be out of the healthcare setting and back home before you can help them. And that's just wild. And so really, if you take the interpretation of how the scripting regulations work, I think that's one of the biggest issues for nurse practitioners and medical practitioners in the formal healthcare setting as far as patient needs. The third one, though, is, again, patients are coming without any former experience or engagement with medicinal cannabis. And so this is something, I do a lot of work in the aged care sector, and this is something I see a lot, because there are so many scenarios where there may even be medical practitioners, nurse practitioners in that formal care setting who would like to engage with this process and have their clients obtain access to medicinal cannabis, but because of their employment obligations, because of the policy of the workplace they're in, they can't even begin to try. And so ultimately, this is why I think a lot of it comes down to, despite the complexity of the legislation, the complexity of the regulations, until we have a broadening of our capacity to have more active and ordinary care for patients under the way in which we would treat them with any other medicine, we're stuck with, I'm not even going to say this imperfect system, we're stuck with this entirely dysfunctional system. And ultimately, we're also confounded by the challenges of many workplaces and employment law that doesn't protect us in breaching that third limb. So, hey, you know, we're in a scenario, we've got someone who's coming in for long-term care, let's explore medicinal cannabis as a care option, and you still can't do it. And that is, you know, morality over medicine. And though I'm not medically trained, that seems weird. It seems wrong. But I don't want to talk about morality too much because as a lawyer, I guess I'm not meant to talk about it. Problem with employment law in Australia is it doesn't directly deal with cannabis as a specific issue. It actually doesn't really directly deal with any type of intoxication as a specific issue. And it never really has. And this has been a major problem. I've got some colleagues at the firm that are doing a lot of great work in and around trying to run cases to push the boundaries of what it means to be a medicinal cannabis patient, or what it means to be a prescriber and advisor in and around the medicinal cannabis sector in heavily regulated workplaces. You know, unfortunately, for a lot of nurse practitioners, for a lot of RNs, they're working in, you know, 95% of the time, government-owned or government-funded businesses. And so the ability to push the boundaries of existing workplace policies is always limited. So how do we try to create a culture of talking around medicinal cannabis? Because when someone comes in and chats to us and says, hey, I'm in a high-risk workplace and I have obtained a script for medicinal cannabis, or someone I know has, or even one of my employees has, what do I do about it? Often we turn around and say, well, actually, not much. Read your employment policy and see what it says. And if you've got a validly constituted employment policy and it doesn't afford you the ability to be, you know, minorly impaired or subject to some engagement with THC or CBD at work, you might be in breach and you might lose your job. And ultimately, as a society, we need to start having a conversation about, well, how do we protect people in these scenarios? And for medical practitioners, for nurses, for registered nurses, how do we protect people who see people in these scenarios and might be subject to policies which restrict them from caring for them? And so the employment law is complicated. It's depressing. So there's a big case, we call it SHARP, BCS infrastructure. Now, this is pretty old in the context of the medicinal cannabis sector. Basically, someone shows up to work and they basically test positive for THC and they're pretty much immediately dismissed under a workplace policy. And the Fair Work Commission in 2015 upholds the dismissal as a breach of company policy. Now, I haven't given you much information, but can someone give me a suggestion of where you might think that would be fair? Mining? Machine operating? Recreational use? Well, I'd actually like to just throw the word impairment out to you all, because ultimately, yes, the purpose of our conversation today And I guess our goal together is to focus on medicinal cannabis. So I'm certainly not going to muddy the waters by talking about recreational use in any way. But if a person is not impaired, then why does it matter if they have an element of or a trace substance in their blood? You know, there are people who are prescribed dexamphetamine or other amphetamines and have high concentrations of those substances in their blood who are allowed to work solely because those substances have been, I guess, a ubiquitous part of the consumption patterns of Australians since before World War II. So I would like to get you to think about the word impairment. So when we're talking about the law, let's see how the word impairment has progressed. Let's see how the importance of impairment has changed over the years. I think that pretty much covers what I just said. As you know, a lot of people that have discussions with people about medicinal cannabis are not actually doctors. They're predominantly nurses. Even having a conversation with people yesterday at a different function, having a conversation with people around the conference today, most of the conversations people are having are actually with nurses, and that's because nurses tend to provide the largest concentration of primary care in Australia, from wards in hospitals all the way to aged care. Most contact that people have with the medical system is with nurses. And so I guess my goal is, if you guys can come out of my talk today with a question of impairment, when I'm talking about my own care, if I'm a medicinal cannabis patient, am I impaired? This is an issue which is coming up again in other states, for example. I know it hasn't been at the forefront so much in Queensland around the mobile drug testing laws, and whether being pulled over and having a trace amount of THC in your system is going to preclude you from driving. And so, again, directing my question at the person who made a comment about recreational use, do you think there is notionally a difference if someone has a nominal concentration of THC? No. And that's it. Unfortunately, there isn't. And it makes the political conversation harder. But I think if we can bring the conversation down purely to the word of impairment, then it's a lot easier to start guiding lawmakers, start lobbying for positive change. That's just a bit of obiter from me, but that's my view. You guys all know how GPs and other practitioners prescribe medicinal cannabis. I'm not going to talk about advertising because I don't think it's necessarily directly within the ambit of what we're talking about regarding nursing regulations, but it's complicated, right? The whole sector is weird. Now, does anyone here know if you can use medicinal cannabis in the workplace if you're a nurse, midwife, doctor? Yeah. Yeah, so the comment was, in Lismore Hospital, patients can sometimes bring their own medicine in and have it be administered. And I think that is the answer. There is no clear law about how someone can consume or use medicinal cannabis in a health workplace. That's right. And so the comment was, it comes down to the doctors being able to prescribe it again, knowing how to prescribe it again. But I would say it comes down to something even simpler than that. Think about a scenario where you're in a privately owned healthcare facility or aged care facility, or even one that is owned by a particular religious or morally guided group. And your workplace policy says that you cannot administer X or you cannot re-prescribe Y because that is within the current ambit of the regulations. Ultimately, there is no unifying framework for the way medicinal cannabis can be prescribed within workplaces for nurses, and there is no unifying framework within the employment law to give people guidance around whether they can use it either. And that's also a problem because we're talking about a sector which suffers from significant mental health issues, a lack of time and investment in self-care and personal care. And we're seeing from a lot of the data coming out of even Australia that a lot of medicinal cannabis prescriptions and care plans are going out to people who are suffering from mental health issues. And so we're really facing a two-pronged challenge in our sector. So yeah, basically most healthcare workplaces have a no tolerance policy. So I believe someone at the back mentioned mining as an area where you might have a no tolerance policy and you might consider that to be reasonable. But what if you're the security guard who operates the front boom gate? What if you're the cleaner who pressure washes the toilet block in between underground shifts, which is a job I actually had when I lived in Wollongong? What if you're the guy who whippersnips the long grass at the front of one of the access roads? So again, yes, a whippersnipper is a hypothetically dangerous tool, but is it too dangerous for a genuine medicinal cannabis patient with a trace amount of THC in their system to be operating? These are the things we need to be thinking when we have these conversations. Privacy, it's a really big issue. If someone that you know, whether it's a patient, a friend, yourself, is exploring or already has engaged in the process of consuming medicinal cannabis and they work in a zero tolerance policy, my current view is that you, your friend, or that someone you know, immediately obtain legal advice. And I don't say that just because I'm a lawyer, but I say that because you'll see from the other cases I run that it is a completely unpredictable environment that we operate in. And so that can often exacerbate the health issues that people are dealing with. And it's something we need to be aware of as a sector. In Heidler and Sydney trains, so 2019, that's 4 years later. So you'd think 4 years, it's not a long time in politics. It's, one and a third prime ministers, probably less. An employee had smoked cannabis the night before a shift, was drug tested, found THC positive, subsequently terminated. They said the dismissal was unfair. Now this is Sydney trains. You would think, to take the mining comment, that's sort of dangerous, I guess. Pretty much everything around a train, in my view, is a life or death situation. This particular gentleman wasn't the cleaner or the conductor of the train. It was an outdoor worker, and they actually found that despite the New South Wales government's zero tolerance policy, this particular individual had been unfairly dismissed. So I guess there's really no reason why this has changed other than society is starting to change its views. Lawmakers, judges are starting to get a better understanding of what it means to be someone who is engaged with cannabis full stop. But in this particular instance, actually a medicinal cannabis user. So not just a recreational user. So this brings me to, I guess, something we're working on at the moment at the firm. And it's a case of Mitchell Rice and Queensland Rail. And I hope everyone's had a chance to, stumble across this. If you haven't, I suggest you Google it. Mitchell's a lovely young dude who looks after his elderly mother. He suffers from severe anxiety and insomnia and has spent over 10 years consuming various different types of obscure and not obscure medications at the behest of various doctors and other advisors. And he's been showing up to work for over 10 years, basically stoned out of his gourd. And after not being able to sleep for a number of nights and his mother's care requirements going up, he finally found a doctor who was able to prescribe him medicinal cannabis, and he did what he thought was the right thing. And he approached his employer before he showed up on site and he said, "Hey, I'm changing to medicinal cannabis. You know that over the last 10 years, I've been on various types of antidepressants. I've been on various types of opiates, and I've been going to work." And this was an engineer who was working on signal boxes near moving trains. And they had allowed him to do his job for that period, again, stoned out of his gourd. And after he showed up with his medicinal cannabis prescription, I mean, I'm not going to go through it too much. Basically, click, 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 he was sacked. Now, 2019, the courts determined that it was an unfair dismissal. Here we are at the end of 2020, beginning of 2021, and ultimately someone has been terminated. Now, general protections claims in Australia are a special type of action you can take against an employer. They're not unfair dismissal. They're in court. They're not in the, what's it called, the Fair Work Tribunal. They're properly heard by a judge, and they can give rights for major damages, not limited damages for back pay. And they can also reinstate things like employment and change workplace policies. And so really this is a case which is currently running now. We're running it on a pro bono basis. I wanted to end my presentation with this because I'd actually love everyone in this room to jump online and Google Mitchell Rice and donate some money to his GoFundMe. He's not paying us, he's got to pay health experts. He's got to engage with some people in this room to explain to a judge and to the Queensland government why impairment is the operative word when we talk about medicinal cannabis and the workplace. And ultimately, you know, I would hope that as a sector, as a group of allied professionals, we would start engaging more proactively with medicinal cannabis ourselves. I know that a lot of people in our sector avoid exploring medicinal cannabis as a potential treatment for their own issues, for exactly the type of problems that Mitchell Rice has experienced. And ultimately something will have to change. And I don't think this is going to be the thing that changes it. It's going to be the work of every single person here, and I would hope not many more, but I suspect at least another generation before we see meaningful change. And so that's my presentation. If you actually want more information about what the regulations are, I've got a working paper and I'll email it to you. Just come grab me for a coffee. Thank you.
Before you go, Lucy just told me that at the beginning, when you were talking about the regulations, she wanted to share this. Well, hang on. You're so tall. I think you can help me here. Okay. Yeah. Lucy will hold the bottom. And so this was the first. You might have the wording better. The first access pathway when regulation. Yeah. Actually, how about I hold it and you explain it? There you go.
Yeah. So for everyone, you probably can't read it from there, but it's a massive flowchart. It's the special access scheme pathway, so the original pathway once the scheme was first introduced. And as you can see, not even a lawyer can understand that. To whoever's actually prepared that flowchart, they're obviously a savant. So,
thank you so much. Thanks.
Thank you.
Thank you. That was a really engaging presentation. I loved it.